Hello, everybody. I'm currently concerned about a war between Snitch and Billy. I'm watching it. Hi, Ava. There's no worries about wars with Ava. Ava's the bestest pup. It's okay, boys. It's okay, boys. You're fine. Just go ahead and lay in this bed. I put your kitty bed up here. You can lay in the kitty bed. They want to go outside, but we're getting freezing rain tonight. And I don't want to subject them to that. Okay, well, I guess Billy didn't want to subject himself to meeting Snitch. And Snitch is the most gentle old man. He doesn't have a fighting bone in his body, and if he does, it broke a long time ago. Out on the mean streets of Toma. I'm all fuzzy and I don't like it. Hi, Ava, honey. You're a good girl. Yeah. Yeah, you're a good girl. I ordered her some more of those beef rings that she loved so much. So those are in the mail. Those are in the mail. Hello, Ixamo1. You beat everybody into the comment section. Oh my gosh, how did that happen? How did you beat Jerry? He sits on the keyboard waiting for me to go live. Sorry, guys. Sorry. I'm trying to Jerryalize that text. But it sounds like Wolf Lord Lover, our sweet, sweet man, is not doing well. He's on an antibiotic. And I don't know where he's supposed to stay. But definitely, Wolf, if you're listening to me, I know. Stay on the antibiotic, buddy. Please. The reason why there's so much antibiotic resistance is because we get off of them before we finish, because we feel better. But it's not better, and we just let our body do the rest of the fighting. But then whatever's left that didn't die off, it's just stronger for the next time you go on the antibiotic or spread it or whatever. It's how things morph. But anyways, thank you for that semi-update, Jerry. You know you're so valuable around here. I hope you know that. Hello, Jerry Matthew Boyd. Hello, Manny. There must be comments that are not showing up for me, because Manny apparently sees something as well that I don't see. And Michelle Moreland sees it. Hello, sweetie. I'm just going to do this right now. Hello, Wolf Lore Lover. Apparently you're in the comment section, and it's not visible to me, and I don't know why. But I know you're there, and clearly you're not feeling well, and I hope you feel better very soon, honey. I'm sorry you're sick. You need homemade chicken noodle soup. And if we weren't 3.5 hours away from each other, I'd bring you some, totally. Hello, Dark Zoomy. Thank you for making me laugh. You're the awesome one. Hello, Purple Kiv. Wow. That's really insightful. You know, all of the stuff that a lot of us have going on. One of them that's always coming up is autoimmune disorders. And we're all so familiar with them. I know. They say it's something wrong with us, but what if it's not? What if our body is doing exactly what it's supposed to do and reacting to environmental circumstances or medications that we have pumped ourselves full of, or toxins we've been exposed to, or foods that we've eaten? It's just something to think about, because there's a good chance that our bodies that were built to work are actually working. And we're just the dummies. Not to say the conditions from birth don't exist, but I just think there's a lot of environmental stuff that goes into it, scientific stuff that we're just not privy to. And I think the government and the medical industry knows a lot more than what they tell us. Hello, Nana Laura, honey. I was 3 years old when he retired. I love you, Nana Laura. There he is, right there. Hi, sweet love. It's wonderful weather we're having. Oh, yes. It's supposed to freeze tonight. Yep. We're supposed to get rain, like 1/4 inch of rain, and it's all supposed to freeze. Relaxing sounds like a good thing. Okay. Snitch has declared it. What was that, buddy? What you got to say? Oh, more food? That's what you got to say? The Artemis flight. I have put NASA launches on, or SpaceX launches on in the background. See, I don't know if any of you saw him sit, but that's exactly what I was talking about. Like how gentle he puts his hips down, and his hips are always hanging over, so he's not putting weight on them. And he's got a lump like right here that feels like a bone that broke and healed improperly. So I'm thinking he got hit by a car, because that bump is right where his back end starts. And that's right where he starts to go into very gentle with it mode. What on earth? One of y'all got me. No, it's okay. It's okay. It's okay. It was just me. My fault. My bad. Why don't you lay in this nice, comfy, fluffy bed that nobody wants to lay in? You just want to see what all I knocked over? It's really not that impressive. A handful of 50-cent pieces. There we go. That'll do her. That'll do, donkey. That'll do. All right, I'm gonna put this back up there without causing an avalanche of hand lotion. And that's pretty much what it is, like 6 bottles of hand lotions, various types. My Eucerin, my other Eucerin, my Gold Bond. I got, there's Nystatin up there too. And then, there's definitely Vapor Rub. Gotta have the Vapor Rub. That's why there's an avalanche. They're strategically placed so that I can push the pumps, put them by height, and access them. Also got my fluticasone nasal spray for the allergies, because God, why would I have allergies with 5 cats and a dog? I just can't comprehend that one. Because I love them. That's why. Excuse me. Wixamo one, I love you. And I've been here with insomnia myself almost every night since. You guys are so amazing. Quit it. I love you guys. Don't you dare, tiny kitten. Hey, tiny kitten. Tiny kitten Esquire. Thank you, Snitch. Thank you for being the bigger of the two. All right, I'm scooching along so we can get started on cases. Hello, Buzzy Bug. That seems to be one of the favorites. Because they can activate it themselves. What you doing in the corner, buddy? What are you doing? Snitch. What are you doing, Snitch? Oh, you're just lying down. No, you're not. Oh, my God. Okay, guys. Hello, C-Rex. I'm going to scoot along really quickly here because I have a mess that I need to clean up real quick. I love you all so much. Please forgive me.
Mr. Paw, are you ready to present your case?
I am, Your Honor.
That's Elise Payne.
That's Caitlin Elise Payne, Your Honor.
Okay.
She is on court security 1.
Okay. This is State of Kansas versus Caitlin Elise Payne. It's case number 2018 CR 78. Richard Paw appears at defense counsel. Caitlin Payne appears at court security Zoom location. Amber Norris on behalf of the state. Probation violation is alleged here. Failing to pay on the case by Ms. Thomas from Court Services, who's on this meeting with us. What is your client's position at this time, Mr. Paw?
Your Honor, she would admit to the one.
Okay, I'm having difficulty hearing you. Anything you can do to enhance your audio, I would appreciate.
I'm sorry, can you hear me now, Judge?
I can make out what you're saying, so please go ahead.
I'm sorry, Your Honor. I've never had this issue before. Your Honor, Miss Payne would admit to the violation. That was failure to pay all costs as directed, forego her evidentiary hearing, and then proceed to disposition on the case.
All right. I think this is one of those matters, Mr. Paw, that I want to hear what your recommendation to the court on disposition is going to be.
Judge, my recommendation on disposition is going to be extending her. If you look in the court record, Judge, there has been multiple journal entries of modification on hers because at time of sentencing, she was ordered to pay $48,000 in restitution. She's gotten that down to approximately $12,000, and that's basically the only thing that brings her before the court today. Judge, to my knowledge, she hasn't been charged with any new crimes. Maybe Ms. Thomas can shed some light on why the warrant was filed. But Judge, she has been trying to make her payments and pay this down. She's paid about 75% of it off, and that's the only reason she's before this court today.
All right. Ms. Thomas, would you add anything at this time to what has already been stated?
No, Your Honor. My recommendation too is for reinstatement and extension.
Very well. Thank you. All right. Ms. Payne,
Yes.
you've heard what your attorney has said to the court, that you would waive any due process hearing that you'd be entitled to today. And again, state would have the obligation of proving a violation by a preponderance of the evidence, something you can challenge with the assistance of your lawyer. You could present your own evidence at a hearing and confront the state's witnesses unless good cause was shown. Among other lesser remedies, of course, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand this?
Yes, I understand.
Do you waive a hearing in this case and stipulate and agree that you committed the failure to pay off your case violation?
Yes.
All right. Court finds that the defendant has knowingly waived her right to a hearing, stipulates and agrees that she's failed to pay off her case. Ms. Norris, I haven't asked you for your specific recommendations. What are they?
Your Honor, similar to what's previously been noted, that the court should extend for at least 12 months and that the defendant should be reinstated to continue working on basically paying the restitution. And it's my understanding, based on the notation we received from the clerk, it's $11,930, which is still left as of earlier this week.
Okay.
The court will need to address additional attorney's fees and the court appointed.
How much? Okay. How much are your fees on this round of proceedings, Mr. Paw?
Judge, let me look at it real quick. I should have anticipated that, but I didn't. My round of fees right now is $132, not counting today.
Thank you. Ms. Payne, do you have any statements that you wish to make in mitigation of punishment here?
No, Your Honor.
What kind of work are you doing?
So I work in sales for a funeral home, and then I also do 2 part-time jobs.
Okay. Ms. Payne, you were originally ordered by this court back in February of 2019 to pay restitution in the amount of $42,934.68, a number which I'm sure you're painfully familiar with.
Yes.
You have made considerable progress on the payment of this case. In fact, I wish more criminal defendants were as diligent about paying off their restitution amounts as you have been.
Thank you.
Certain consideration needs to be given to that. The court believes that what's been recommended here makes sense. I think you're making good faith efforts to pay this case off in a consistent fashion, and the court's simply going to, I'm going to revoke your probation, but reinstate it.
Okay.
For a period of 1 year from today's date. In other words, to March 20 of the year 2027. Perhaps with a great deal of optimism, I hope you can get the case paid off by then.
Yes.
Also, I think in consideration of the efforts that you've made to pay restitution, I'm going to waive any additional bids amounts. Not that Mr. Paw's services haven't been valuable, but I really want you to focus on what you would owe a victim in this case. And if you're able to continue to pay that down, adding additional bids amounts at this point just doesn't make sense to the court.
Thank you,
So I'm going
Judge.
to waive any additional assessments at this time and appreciate the good faith efforts that you continue to make.
Yes, thank you very much.
Oh, perhaps Ms. Thomas can handle an extension if you don't have it paid off in a year, but she still sees that you're making progress. But again, your probation is extended to March 20 of 2027 at this juncture. Ms. Thomas, anything else we need to address on this case?
No, Your Honor.
Ms. Norris?
No, Your Honor, thank you.
Mr. Parr, are you aware of anything further?
No, Your Honor, thank you.
Okay, did you have any questions about the court's orders today, Ms. Payne?
No, thank you, Judge.
Okay, all right. It's quite all right. If there's nothing further, then the Caitlin Payne matter will be in recess. Mr. Paw and Ms. Payne may leave the meeting at this time.
Thank you,
Thank
Your Honor.
you.
All right, I noticed that I have James Watts on this meeting. Mr. Watts, are you ready to present on your case?
Yes, Your Honor. Ms. Swan is at court duty.
Okay. This is State of Kansas versus Pamela Sue Swan, case number 2025 CR 200. Pamela Swan appears at the court security Zoom location at the Butler County Judicial Center. James Watts is defense counsel, Amber Norris on behalf of the state. This matter comes before the court at this time on review of the probation status of this defendant. The allegations before the court in the Swan case would appear to be failure to report to the ISO as directed, apparently failing to report to Sedgwick County in January, apparently after an administrative transfer of her probation, and then failure to obtain a Senate Bill 123 alcohol and drug evaluation as alleged by Christy Ashenfeld from Community Corrections, who is on this meeting with us. Mr. Watts, what is your client's position regarding these allegations?
Your Honor, I've discussed the allegations with my client. As to the original warrant to show cause dated February 5, she would acknowledge she failed to report to the ISO as directed. She'd also acknowledge that she failed to make contact with Sedgwick County Community Corrections. She will note, however, she was failed to report on January 20 over there. She did not get a letter to report over there by January 20. She got that letter at a later date. She would all acknowledge that she'd failed to report or failed to obtain her Senate Bill 123 drug and alcohol evaluation. I would note, however, this case was only sentenced in December of last year, so at this point is only approximately 3 months old. Finally, as to the addendum to the additional warrant, my client would acknowledge that she tested positive for methamphetamines on February 27th. She'd waive hearing on those allegations.
All right. All right, Ms. Swan,
Yes,
based on the announcement of your attorney in the case, it's my understanding that you intend to waive hearing. You understand that you are entitled to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence, confront the state's witnesses unless good cause was shown, and unless the court could consider, among other lesser remedies, just an outright revocation of your probation and having you serve the remaining balance of your sentence incarcerated. Do you understand these things?
yes,
Do you stipulate and agree that you committed the violations which the court had read out in this case earlier?
yes,
All right. Court finds that the defendant has voluntarily waived her right to a hearing, stipulates and agrees that she committed the violations as read off by the court in this case, which are substantial and material violations of the terms and conditions of Pamela Swan's probation in the case. The court will turn to disposition of this matter. Ms. Norris, first I'll ask for your recommendations regarding an appropriate disposition.
Your Honor, this is defendant's first warrant to show cause. She was initially placed on probation in December of 2025, so it doesn't appear that she would need any kind of an extension at this point. We would ask that the court order her to continue on community corrections probation with all previous and standard conditions. would be asking for 2 days in the county jail as a sanction for the issues that she's been having. And court will need to address additional court-appointed attorney's fees in the bid's application fee.
Very well. Ms. Ashenfelter, do you have recommendations independent of what the prosecutor recommended?
No, Your Honor.
Thank you. Mr. Watts, your recommendations regarding an appropriate disposition.
Your Honor, we understand the request for a 2-day dip in this matter. I don't know that this is inappropriate. My client has asked, she is working full-time. Her days off are Tuesday and Wednesday, and she very much like to, if a dip is required, that she serve that dip on a Tuesday and Wednesday so it doesn't interfere with her work and she can continue to keep her job. She suggested coming in Tuesday morning and would be released Thursday morning, this upcoming Tuesday and Wednesday.
What is this job that she has that has Tuesdays and Wednesdays on?
Ms. Swan, where are you working and what are you doing?
I do night audit at the Holiday Inn, Wichita South, at the hotel over there.
Okay. How much money are you making at that job?
I make $13.50 an hour.
And you get 40 hours a week?
Yes. 40 plus most of the time.
All right. All right. Is there anything, Ms. Swan, that you would say in mitigation of punishment here?
I mean, I understand I did wrong. If you need to extend, I'll extend. I mean, if I need to do more community service, I will do anything. I've just passed a UA on Friday and I've just started feeling good, and I know I've got to do my time, but I'm just hoping that everything can still work out. I did start treatment. I go 3 times a week now. So.
As the court would observe, Ms. Swan, you should have started your treatment back in December when you were ordered to.
Yes, at the time I thought I was moving to Wichita, but it ended up I didn't get to move to Wichita, and that's why it all got befuddled. And I mean, that's my fault. But as soon as I knew that I wasn't getting able to move to Wichita, I had the appointment set up and everything right there in Augusta.
All right. Well, let me just remind you, Ms. Swan, that at the time of your sentencing, you received an 11-month prison sentence.
Yes.
And with some direction from the Kansas legislature, you were granted the privilege of probation as an alternative to that prison sentence. So,
Yes.
2 alternatives. You complete probation requirements and don't go to prison, or you don't complete probation requirements and you do go to prison. Those are the 2 options. Your lack of progress early in this case would seem to indicate to the court that you really don't appreciate the privilege of probation and you just as soon do your time. But what has been recommended to this court seems to be consistent with current interest of justice. You're relatively early in your probation period. You've taken some steps to correct the deficiencies which existed, and there's still plenty of time left on your original probation to complete, because that was up to 18 months. I don't see the need for an extension. This court will impose as a sanction for noncompliance a 2-day dip in the Butler County Jail. Normally speaking, Ms. Swan, I have little sympathy for people who claim they have to go to work. They should have thought about that before they violated in most instances. However, I also understand with this felony on your record, you may not be that employable. There are some employers that will just disqualify any convicted felon. You do appear to have a full-time job that's working for you in Wichita. This is a rare occasion for this court, but I think at defense counsel's request, I'm inclined to allow you to report to the county jail to serve your 2-day dip on Tuesday morning, to be released on Thursday morning. I need a set time, though. What time are you going to be there?
Yeah, I get off at 7, so let's make it 9 o'clock. That way there's nothing that'll get in the way.
You must report to the Butler County Jail at 9 o'clock a.m. on Tuesday. Let me get that date clarified. I think that would be the 24th. Correct, counsel?
Yes, Your Honor.
March 24, 9 o'clock a.m. at the Butler County Jail. And if you're not there, it's going to be another probation violation. So you cannot mess that up. You'll serve 48 consecutive hours and be released March 26th around 9 o'clock a.m. or when they get you processed out to serve your dip sanction. Then you'll be reinstated on probation for the original period at this point, which is up to 18 months. Ms. Ashenfelter, what direction would you give Ms. Swan?
Your Honor, we already have an appointment scheduled, so nothing further is needed today.
Okay, and obviously it's outside of the period she's going to be in jail, correct?
Correct, Judge.
Okay, all right. Ms. Swan, you've got an appointment already with Ms. Ashenfelter. You need to make sure you keep it, and all subsequent appointments. It's time to take the probation seriously in all material respects, Ms. Swan. I worked with you this one time.
Thank you.
If you have to come back before the court, it may not go as smoothly for you. Noting that the defendant is working full-time, I am going to assess an additional bids application fee of $100 and an additional attorney fee of $100 and waive any remainder. That is a financial sanction as well as the loss of liberty sanction the court's imposed. It's something that you owe, and it's going to be added to any existing balance that you have. So again, $100 bids application fee, $100 additional attorney fees for a total of $200 extra.
Okay.
All right.
So in Kansas, while you're on probation, they have a 2-day dip sanction for your first violation, where you have to serve 2 consecutive days in the Butler County Jail. And then after that, you would have to go to a dunk, which is 3 days for your second violation on probation. Your third violation, they consider revocation. Usually it's just another sanction with a couple of days in jail, because everybody deserves a chance. I know. We should study them for science. Oh, you just wait. See the next methy gal, the one in the bottom right-hand corner? We get to see the progression of her methiness. I know I have run her before, kind of piecemeal, but I went through and found all of the cases that I had with her, and it's astonishing to see what the drugs, the sobriety, and then the drugs do to this girl. That's how it should be. That's how it should be. Oh, geez, that never works. Who would do such a ludicrous thing? Work? It never pans out quite right.
Ms. Norris, anything further we need to pursue on this Swan case?
No, Your Honor, thank you.
Mr. Watts, anything further?
No, sir, thank you.
Ms. Ashenfelter, do you need any clarification?
No, Your Honor.
Ms. Swan, do you?
No.
Okay, you're free to go at this time, but remember the time that you need to report. And I just want to make a point here, Ms. Swan. I get asked to do this quite a bit, and I very rarely grant it. If you don't do what you're supposed to do, you're going to mess it up, not only for yourself, but any other defendant that asks me for a similar accommodation. So you appear to be proceeding here in good faith, and I just hope you keep the appointment that you have set.
Yes, I will, sir.
Good luck on successful completion of your probation, Ms. Woman.
Thank you.
There's nothing further. The Pamela Swan matter will be in recess. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Melinda Marie Needler. It's case number 2024 CR 453. Brett Sweeney appears for the state of Kansas. Shannon Cooper is defense counsel. There's no appearance from what the court can envision here from the defendant, which isn't really surprising. Back on December the 19th, this court had set several court dates following preliminary hearing waivers. At the arraignment, it was established there would be a status conference on February 6th at 11, pretrial conference for today at 1:15. However, the docket notes from February 6th, the first of those settings, indicate that the defendant who was required to appear, did not appear. The court declared bond forfeiture, bench warrant, and placed a no bond hold on the defendant. Counsel, to my knowledge, the whereabouts of Melinda Needler are still unknown. I don't think she's in custody. Ms. Cooper, do you have any additional information for the court?
I don't, Your Honor, and I checked to see if she was in custody anywhere locally today, and I haven't seen that she is, so I do not know. I have not heard from her. I haven't been able to reach her either.
All right, I'll inform counsel that due to the defendant's known absconder status, the case was taken off the jury trial docket next week already by this court. No further scheduling regarding pretrial conference or jury trial will be made until Ms. Needler is in custody and is available for this court to schedule with. So at this time, the bond forfeiture, bench warrant, no bond hold orders remain. In regard to Melinda Needler, further scheduling will be done when she's taken into custody and is available to us. Mr. Sweeney, anything else we need to address currently?
No, Your Honor.
I didn't hear anything, Brett.
No, Your Honor.
Okay,
Can you hear me? He said no, Your Honor. That helps.
I trust that he did.
Okay.
For some reason, the volume didn't come through. Ms. Cooper, and there's nothing else from your side at this time?
I have nothing further at this time, Your Honor. Thank you.
Then the Needler matter will be in recess at this time. This meeting may be ended for all. Thank you, Counsel. Needler, it's case number 2024 CR 453. Member Norris appears for the state of Kansas. Shannon Cooper is defense counsel. Defendant Needler appears from the Butler County Jail Zoom location. This matter comes before the court at this time for further proceedings. Back in February, the defendant failed to appear for a scheduled court appearance. Court ordered bond forfeiture, bench warrant, and no bond hold. The case was kept on the trial docket for April. At the pretrial conference, the defendant was deemed to be an absconder. Case was taken off the trial docket with the announcement that the case would be rescheduled for trial once Ms. Needler was picked up. The bond forfeiture, bench warrant, no bond hold order remained in effect. Eventually, obviously, Ms. Needler has been picked up. She's currently in the Butler County Jail. What announcement is made regarding the status of the case at this time, Ms. Cooper?
Thank you, Your Honor. Ms. Needler wishes to enter a plea of no contest to count one. I did not hear back from Ms. Norris about whether she'd be willing to dismiss count two. If her answer is no, then Ms. Needler would enter a no contest to both counts, but we were hopeful the state would be willing to at least dismiss count two and schedule the matter for sentencing. We'd also like to address a bond being set for Ms. Needler today. I anticipate that she would be presumptive probation for this case.
And Shannon, I did respond, but it actually is saying that you're not in the meeting. But yes, that's
okay.
your request
Okay.
your request is fine.
Okay, thank you.
Ms. Needler, it's been announced that you now would intend to enter a no contest plea and accept conviction for count one in this case. I don't know if you have your charging document before you, but count one is theft, a level 9 non-person felony. Is that indeed your intention?
Yes.
I've got a number of questions I need to ask you regarding the taking of a felony plea. If there's anything asked of you that you do not understand as we go along, I'll give you the opportunity to confer privately with your attorney again. Just let the court know if you need that time to get further advice, okay?
Yes, Your Honor.
State your full legal name for the record.
Melinda Marie Needler,
How old are you right now?
32 years old,
What's the highest level of education that you've attained?
high school diploma.
All right. Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, no, sir.
All right. Have you ever been adjudged to be mentally ill?
No,
Are you currently under the influence of alcohol or any drug?
absolutely not.
Are you currently taking any type of prescription medication? Is that a no?
No,
All right. Are you supposed to be taking mental health medications that you are not currently getting?
no,
All right. So as you said today, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
yes, Your Honor.
All right. Do you understand the nature of the charge of felony theft as charged in count one?
Yes, Your Honor.
You understand that when you enter a plea of no contest, you are not necessarily admitting that you committed this act, but you're also not contesting that you be convicted of this act that's charged by the state just the same.
Yes.
You also understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to that charge.
Yes, Your Honor.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Ms. Cooper, and that at a trial, you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
Yes, Your Honor.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, Your Honor.
Understand that when you enter a plea of no contest, you give up your right to a trial by jury and that requirement that you be found guilty beyond a reasonable doubt.
Yes, Your Honor.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, Your Honor.
Are you aware of the possible sentence that could be imposed as a result of this no contest plea that you're attempting to make?
Yes, Your Honor.
Let's go over those. This would be a level 9 felony under Kansas law. In the most favorable criminal history category of I on the Kansas Sentencing Guidelines Act non-drug offense grid, you could receive as little as a 5-month prison sentence. In the worst criminal history category of A, you could receive as much as a 17-month sentence. So the sentencing range is 5 to 17 months in prison, depending on your criminal history. As you sit today, Ms. Needler, we do not know with certainty what your criminal history is. You better than anyone else here really should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of that research as of the date of sentencing, that will determine where you fall along the level 9 line, and then you'll be sentenced accordingly. You understand that?
Yes, Your Honor.
You also understand that if at sentencing it's determined that you have 2 or more person felonies on your record already, you would be presumptive prison here.
Yeah, I don't have any person felonies.
I understand that. I just want to make sure you understand that if you do, you're looking at a prison sentence here.
Yes, Your Honor.
All right. You also understand that you could receive up to a $100,000 fine for this offense?
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of your legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also realize as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
You also understand, Ms. Needler, that the Kansas Sentencing Guidelines Act is much more than that grid page that I referred to earlier. It's an entire book of sentencing rules and laws. Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or
Yes.
otherwise affect your sentence?
Yes, Your Honor.
Have you had an ample opportunity to fully discuss legal matters like that with your attorney, Shannon Cooper, before
Yes.
proceeding here today?
Yes.
Are you satisfied with the services and advice given to you by your attorney?
Yes, sir.
Now, this no contest plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
Is there anything that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
No, Your Honor.
Ms. Needler, do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So let me ask you, how do you formally plead to the charge in count 1, felony theft?
No contest.
The state would provide a concise statement of factual basis.
Your Honor, on September 23rd, 2024, here in Butler County, as noted in the information, trailer with a welder and some tanks and welding wands and tools was taken from an address out in the county.
What's hilarious is she stole a trailer full of welding stuff, and she actually, in this hearing anyways, kind of looks like the girl on Shameless who became a welder. Maybe it was her inspiration.
Without the permission of the owner, who was Ben Griffith. And Your Honor, the trailer was located in the city limits of El Dorado within 24 hours of the taking. And the defendant was with 2 other individuals in the vehicle that had this trailer with all this equipment attached to it. And they were actively working on trying to appear to sell that piece of equipment either online or through electronic device, which showed that there was no intention for it to be returned to the rightful owner. And the value of the trailer and tools was well over $1,500.
Ms. Needler, do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for felony theft in count 1, a level 9 non-person felony?
Yes, Your Honor.
Ms. Cooper, are you aware of any legal reason why the court should not accept your client's plea?
No, Your Honor.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
Ms. Needler, are you aware of a legal reason or any other good reason why the court shouldn't accept your no contest plea made here today?
No, no, sir, Your Honor.
Court will accept the no contest plea made by the defendant, Melinda Needler, and finds that that plea is made voluntarily. She has an understanding of the nature of her charge and the consequences of her plea, and a factual basis for the plea does exist. Court finds her guilty and adjudges her therefore convicted of felony theft, a level 9 non-person felony. Count 2 is dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Ms. Needler's criminal history, and the court will set an appropriate date for sentencing. We generally allow about 2 months for that pre-sentence report to be compiled and presented to the attorneys in the court. So we're going to be looking at early July. Also, if you check your availability for 11 o'clock a.m. on Monday, July 7.
Yes, that looks good to me.
Ms. Norris?
That should be fine, Your Honor.
All right. Court will set sentencing in the Needler case for Monday, July 7, 11 o'clock a.m. Obviously, Ms. Needler must fully participate in that sentencing proceeding at that time. It is contemplated that that sentencing be conducted by Zoom. Again, Monday, July 7, 11 o'clock.
Is there any way that that we could address like a bond with if I get an ankle monitor?
Ms. Cooper?
Thank you. I would ask the court to consider that. Ms. Needler explained to me some of the circumstances surrounding her previous failure to appear. A person who was providing her with housing was also obligated to care for an elderly sick relative. And that person was in jail, so she took it upon herself to help with that sick relative. Was unable to come to court. She wants today to apologize for not following through or appearing until today, or until she first appeared. I think it might have been on Friday last week. But she assures me and wants to assure the court and counsel that she'll appear for sentencing. She'll cooperate with pretrial with the pre-sentence investigation process with court services. She's sober now, wants to maintain sobriety. She's even looked into potentially residing in a halfway house. She, like she indicated a couple minutes ago, is willing to be monitored with a GPS electronic monitor to make sure she is where she's supposed to be at all times. So I'm asking the court today to set an OR bond, allow her to get back out and to get the treatment she needs, as well as participate fully in that pre-sentence investigation process from not in custody.
Does the state take a position on this request?
Your Honor, I would agree that the defendant will be presumptive probation from what I've seen in her history. Your Honor, based on the two failure to appear instances, one in February and one in April, I'm not sure that OR bond is necessarily appropriate, but I have no problem with the court setting an appropriate bond. I believe that this juncture, a no bond hold still remains on her case. Obviously, we've made some good progress today with the plea, so I'll leave that to court's discretion regarding amount.
Very well. Ms. Needler, earlier you suggested that you wanted to personally address the court about this?
Yeah, I mean, so whenever if I am able to leave here today, my plan is to go to stay at one of the second chance house here in El Dorado. I really honestly 100% was taking care of a 100% paraplegic man. I called my attorney the day that I had the first court, and I was minutes late, and she told me that it was too late already because I was on my way to her office at the time.
She sounded so confident there. When I get released today. Hopefully, when I get released today. Sweetie. You had FTAs. I don't think you're getting released today.
I was stuck in Andover taking care of him at a hotel, and there really was nothing I could do. And because of me being scared of that warrant and of being in jail, that's the only reason I didn't come in. And I didn't even know about the second court date that you guys had scheduled. But I am willing to do ankle monitoring or whatever I need to do possible. But I really would ask. I don't have a whole bunch of money, but I understand it's probably going to cost me a little bit to get out of jail.
Ms. Needler, you said some surprising things that I'm going to comment on here. You were apparently walking and on some sort of device back in December when we addressed your case. At that time, the court accepted a preliminary hearing waiver. At your arraignment, a court date was set for April the 4th for pretrial conference and a status conference in which you were ordered to appear at the Butler County Judicial Center, not your attorney's office, but at the Judicial Center, was set for February the 6th.
Yeah, that's the first.
Notes from February 6th indicate that Ms. Cooper was late, so we didn't start right on time. You weren't there, and the court ordered bond forfeiture bench warrant on a no bond hold. Furthermore, docket notes indicate that we kept the case on the pretrial conference and jury trial dockets. So you had another court date set for April the 4th that you were given by this court back in December.
I know, and I
You're
apologize.
given 2 court dates. You just told me that you didn't know about it. Yes, you did.
Okay, I apologize. I didn't realize that I had the 2.
Well, okay, if you showed up at either one of them, you'd probably be in pretty good shape right now.
I know, Your Honor.
Yeah, sorry, Your Honor. It's really hard to remember things when I'm on meth.
The reality is you've shown yourself to be wholly unreliable to show up for any court date on your own.
Listen, Your Honor, I really, with the ankle monitor, that way you guys know exactly where I'm at and that I am doing what I'm supposed to be doing. You know what I mean? Because there's no way to be able to lie that way.
And how are you in your situation going to afford the cost of electronic monitoring?
Oh, guys, I have to see, I have to see Judge Ricky's face again. It was beautiful. It was something of beauty right there.
by this court back in December.
I know, and I
You're given
apologize.
2 court dates. You just told me that you didn't know about it. Yes, you
Yeah.
did.
Okay, I apologize. I didn't realize that I had the 2.
Well, okay, if you showed up at either one of them, you'd probably be in pretty good shape right now.
I know, Your Honor.
The reality is you've shown yourself to be wholly unreliable to
That's
show
why.
up for any court date on your own.
Listen, Your Honor, I really, with the ankle monitor, and that way you guys know exactly where I'm at and that I am doing what I'm supposed to be doing. You know what I mean? Because there's no way to be able to lie that way.
And how are you in your situation going to afford the cost of electronic monitoring?
I get disability every month.
Hmm.
So I can pay the cost for it.
It could very well be that you may have to go through 1 or more assessments as part of the pre-sentence investigation process. If
Yeah.
you're in jail, Ms. Needler, I have no doubt that court services will be able to find you and conduct those assessments. If you're out in the community somewhere, I don't have that confidence.
Your Honor,
Further,
wait, can I say one more
you tell
thing?
the court as a explanation as to what you're going to do now if you get out. You say that you're going to go to treatment and you're going to go to a halfway house, but this case has been pending in the system for 7 months and you haven't done those things.
Yeah, but no, okay, that's not true. If you can talk to Don Kirkman. I was scheduled to go to treatment on Monday last week. I already went and got my SAC evaluation. I already had a plan to go to Grand in Tulsa, Oklahoma, to a treatment facility. Like that was already in place.
Okay, but you're in jail now.
But
so
right,
you
and
can't
that's
go
the
to
only
that.
reason that's the only reason why I'm not already there. And but those things were already set in place so that way I could get the treatment I needed.
All right. Well, I think there's a reasonable chance that I can keep you away from controlled substances by keeping you right where you are. I don't see any grounds here for an OR bond or even reinstatement of any bond in this case, with an electronic monitoring condition or not, Ms. Needler. I think you need to stay right where you are right now. I understand your attorney's request. I understand your statements.
Hold on, can I say
Even though
one more
you
thing?
were asking me earlier to listen, I have listened.
Wait, can I say one more thing? A very close friend of mine died yesterday, and I this is one of the biggest reasons I'd like to get out.
Well, I'll tell you what, Ms. Needler, you should have thought about that before you blew off court. You didn't surrender yourself on this deal.
Listen,
You had weeks and weeks.
I did
you could have
surrender
tried to
myself to
make this
Don.
right.
I did
Well,
surrender.
I don't think you and I arguing are going to accomplish anything, Ms. Needler. Court's decision is that I'm not going to reinstate a bond. You're on a no bond hold order due to failure to appear, not once, but twice on court dates that you were given by this court. So the court's order is going to stand. You're going to remain in jail at this point. We'll address whether you're eligible for release at your sentencing in July. And again, there are implications and consequences to you not showing up in court when you are supposed to.
Can I say one more thing also, Judge Ricky?
You can go ahead and say it. It's not going to make any difference.
Okay, well, so a lot of my why I was having issues getting to court was because I was set to not have any contact with Matthew Denny, and that's where I resided. So I was having a hard time with housing then, and I have housing now.
Indeed, you do. Sponsored by the Butler County Sheriff's Office. And for the next couple of months, that's what your housing is going to be. All right. Request for bond, quite obviously denied by the court.
She invoked every excuse. Seriously. She had I was taking care of the elderly paraplegic in a hotel room. So invoking both the taking care of someone and the homelessness in one little role there. And then she revisits the homelessness right at the end there, but claims that that's not the case any longer. Oh my.
The bond forfeiture, no bond hold order remains in effect, pending further proceedings in the case. And again, we've got our sentencing date set for 11 o'clock a.m. on Monday, July the 7th. All right, Ms. Cooper, anything further at this time?
No, Your Honor, thank you.
Ms. Norris?
No, Your Honor. Thank
Very
you.
well. And the Needler matter will currently be in recess. State of Kansas versus Melinda Marie Needler. It's case number 2024 CR 453. Defendant appears from the Butler County Detention Facility Zoom location. Amber Norris appears on behalf of the state. Shannon Cooper appears as defense counsel. This matter comes before the court at this time for sentencing. Court's docket notes that the defendant had appeared on May the 2nd, entered a no contest plea to count 1 felony.
Holy cows! Look what sobriety has done to her. Her hair looks better. Her skin looks better. She looks human.
Only theft, a level 9 felony. A pre-sentence report was ordered. Sentencing set for today. Court has received a pre-sentence investigation report compiled by Tony Bauer, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Ms. Norris, is there any objection to the criminal history which is stated in the report?
No objection.
Any objection by the defense, Ms. Cooper?
No, Your Honor.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not be pronounced in the Needler case here today?
No, Your Honor.
Ms. Cooper, are you aware of any such legal reason?
No, Your Honor.
Ms. Cooper, is there any dispute regarding restitution amount in this case?
No, Your Honor.
All right. Well, that's Ms. Needler. Ms. Needler, are you aware of any legal reason or any other good reason why a sentence should not be pronounced in your case here today?
No, Your Honor.
All right, the court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Ms. Cooper?
No.
Are there any victims and members of a victim's family present who desires to address the court in relation to this sentencing? The court finds no such persons present on the meeting, so the court at this time will ask for recommendations from counsel regarding an appropriate sentence, beginning with Amber Norris on behalf of the state of Kansas.
Thank you, Your Honor. State would be recommending the presumption in this matter, which is probation. Defendant would be able to earn up to 20% good time credit and would be subject to 12 months post-release if necessary. Ask the court assign her to 8 months in the Department of Corrections, but 12 months community corrections probation with all standard and PSI recommended conditions, including a drug alcohol evaluation, and that she follow through on the recommendations, and specifically that she have no contact with the victim or the co-defendants, which include Devin Ward and Matthew Denny. Your Honor, she has earned 75 days of jail time credit as of today's date. Ask the court assess the costs and fees of the action to the defendant. Court will need to address court-appointed attorney's fees and the bid's application fee. Your Honor, would ask that the court assess restitution, and Your Honor, the information that is in the or the number that is in the PSI is not correct. Some of the items were recovered. Obviously some of them weren't. So Your Honor, state would be requesting $2,000 joint and several with the co-defendants as restitution to the victim, in this case, Ben Griffith. And Your Honor, I don't think I have any further recommendations for the court at this time. Thank you.
Very well. Ms. Cooper, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. I think the state's recommendations are appropriate. I think restitution needs to be ordered joint and several with co-defendants. As Ms. Norris stated, Ms. Needler has already served 75 days in jail on this case. She's ready to start probation. I think the recommended condition that she submit to a substance abuse evaluation and follow recommendations is also appropriate. She tells me she'll be a successful probationer, and she's ready to get started, Your Honor.
Very well. How much are your fees in the representation of this client?
I think they'll add up to about $1,400, Your Honor.
All right, thank you. This time, the court will address the defendant, Melinda Marie Needler, personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Needler? I'm sorry, I didn't hear what you'd said.
Just that I'm ready to take responsibility for what I did, and I will accept whatever punishment you give me.
Very well then. Court will pronounce sentence at this time. The court hereby establishes count 1 as the base sentence in this case for the offense of felony theft, a severity level 9, non-drug, non-person felony in which the defendant has a criminal history score of G, thus placing her in grid box 9G. Court hereby sentences the defendant to a term of 8 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed. Court does find that in grid box 9G and no special rule application, this is a presumptive probation case. This court will grant the defendant 12 months initially of community corrections probation, standard conditions of community corrections probation. Court finding community corrections is the appropriate supervising agency due to the high risk score on the WRNA. The conditions shall include reporting to an officer as directed, observing all laws. The defendant shall, within 45 days of today's date, obtain an approved substance abuse evaluation and abide by the recommendations of that evaluation. She shall not possess or consume alcohol or illegal drugs while on probation. At her supervising officer's request and at her own expense, she shall submit to random breath, blood, and urinalysis testing, perform any community service work consistent with program requirements, gain and maintain employment suitably throughout her probationary term, notify her supervising agency of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. She shall have no contact with the victim in this case, Ben Griffith or his property, or any of the co-defendants in this case. The defendant shall abide by any curfew or travel restrictions imposed by her officer, avoid disreputable characters and places. She shall not possess firearms or dangerous weapons, follow standard conditions of probation, make monthly payments in a manner acceptable to the court. Community corrections is authorized by the court to require the defendant to meaningfully participate in the MRT program. She shall comply with any mental health treatments and medications. Mr. Bauer, you recommend apparently separate mental health evaluation, is that correct?
Your Honor, she advised that at the jail she had been doing some stuff there. My recommendation was that if that was not something that can continue on, that she go in and get an evaluation done and comply with that due to the need for the mental health medications that she is on.
All right, the court will adopt the recommendation that if she's not already in mental health services and can continue them, she shall obtain an evaluation and comply with the recommendations of that mental health assessment. Defendant is assessed felony docket fee, felony probation fee, community corrections fee. What kind of work are you going to do when you get out of jail someday, Ms. Needler?
When I get out of jail someday, so I plan to try to go get a job doing graphic design and advertising, but I'll take whatever job I can get right now.
The court finds that this defendant already has a considerable amount in fees to pay. The court will assess a bids application fee of $100 but waive any legal fee assessment in the case. Ms. Needler, I will expect you to pay at least $50 a month on these obligations starting with August of 2025 and every subsequent month until you get your case paid in full. I don't think that's going to work a burden or hardship on you at such a modest amount. Further, Ms. Needler, this type of theft needs to be stopped in our county. You're a convicted felony thief. You should do considerable jail time as a result of your behavior and involvement in this matter. The court allows up to 60 days as a condition of probation However, I will note in your case, thanks to your failures to appear in court, you had your bond revoked. You've already served 75 days total. So the court will release this defendant on community corrections probation at this time. I do have Christy Ashenfelter from Community Corrections on this meeting. Ms. Needler, you're going to need to stay on this meeting after everybody else leaves it so that you can meet briefly with Ms. Ashenfelter, follow Ms. Ashenfelter's direction regarding what you need to do next on your reporting probation with their office. Do you have any question about that, Ms. Needler?
No, sir.
All right. Got some other matters I need to cover. Court's already covered the issue of jail time credit. Again, 75 days are awarded. Regarding the issue of restitution, the court orders the defendant to pay $2,000 in restitution, joint and several with her co-defendants, to Ben Griffith, the victim in this case. Some point in the future, Ms. Needler, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seeking expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have the right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Ms. Needler, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. In reviewing my notes from this sentencing, Ms. Norris, are you aware of any other sentencing-related matter which the court needs to address?
No, Your Honor, thank you.
Ms. Cooper, are you aware of anything further to be addressed here?
No, Your Honor. Thank you.
Importantly, Ms. Needler, do you have any questions about the court sentencing orders?
No, Your Honor. Thank you.
Ms. Needler, if you have other holds on you, I'm not releasing you from those. But the hold in this case is being removed at this time so that you are able to start your community corrections program.
And this, my friends, is where it was supposed to end.
All right. And again, I want you to stay on the meeting and meet with Ms. Ashenfelter after we recess court proceedings and everyone else leaves the meeting. Defense counsel, of course, can stay if they so desire. All right. If there's nothing further, then the Needler matter will currently be in recess. We can stop recording and broadcasting. All right, I have an individual seated at the detention facility's Zoom location. I'm going to expect that that's Melinda Needler. She's nodding yes. Shannon Cooper is the defense attorney. She's on the meeting. Ms. Norris, I'll kind of need you back. Okay, thank you. And I will call State of Kansas versus Melinda Marie Needler, case number 2024 CR 453. Again, Shannon Cooper appears as defense counsel. Melinda Needler appears from the jail Zoom location. Amber Norris by Zoom on behalf of the state of Kansas. Once again, this is a review of the defendant's probation and hearing on allegations. Apparently, the defendant was arrested in Sedgwick County and did not notify her officer of that law enforcement contact, failing to report on what looks like 4 occasions in December and January. Defendant had not provided verification of employment, verification of completing an alcohol and drug evaluation, not providing verification of completing a mental health evaluation, as alleged by Teresa Stanfield, Community Corrections Officer, who is on this meeting with us. What are your client's intentions regarding these allegations, Ms. Cooper?
Thank you, Your Honor. She wants to admit that she's been in violation. She admits that she's violated probation as listed.
And Your Honor, unless I miss it, I think the court may have missed some other violations But there was also an addendum that was filed on March 16th.
It is not before me.
The addendum notes on February 5th, the defendant pled guilty and was convicted of driving while suspended in Sedgwick County District Court with case.
Is that related to the arrest that I referred to earlier?
I don't think so.
Okay, the community corrections officer is shaking her head no. So go ahead and continue, Ms. Norris.
And Your Honor, the conviction date or the offense date on that was November 8th of 25. And then on February 3rd, the defendant was arrested by Wichita Police Department and booked for multiple, sounds kind of drug related, and did not notify her ISO of that contact. And then according to that same police report, she was having contact with Michaela Starkey, who is a known drug felon, which violates, staying away from other persons, disreputable or on supervision. And then also the defendant has not provided proof of making any court payments. And specifically, she was to make $50 monthly payments beginning in August of 25, and she has not done that, according to her ISO. Those are the allegations that were set forth in the addendum filed on Monday.
I did want to say that the times I get
Just a minute, Ms. Needler. Hang on just a second. Okay. Ms. Cooper, is your client intending to stipulate to these violations as well?
She stipulates to that they happened. I don't know that she was on this term of the probation. I was just going to take a look at our journal entry from the hearing December 5th. I think that the latest conviction, the date of offense might predate the December 5th hearing we had on this case. But she doesn't deny that she got convicted in Sedgwick County.
All right. And the association with a known drug felon?
I didn't know that she was a drug felon.
So is that a
Your Honor,
no?
maybe not known to her, but apparently known to Ms. Stanfill as a drug felon.
Fair enough. And does she stipulate that she hasn't provided proof of making any court payments?
Yes, Your Honor.
All right. Okay, Ms. Needler, you've heard what your attorney has stated. You are entitled to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, Ms. Cooper, present your own evidence at the hearing, confront the state's witnesses unless good cause was shown, and among other lesser remedies, especially in your case, court could consider an outright revocation of your probation and having you serve the remaining balance locked up, noting that you've had a previous dip sanction imposed by this court earlier. Knowing these things, is it your intention to waive hearing and stipulate and agree that you committed these violations as what has been discussed on the record here?
So I did mess up on my probation. I am aware of that, and I do stipulate to that. I just wanted to let it be known that the 4 times I missed going in to see her, I was in the
Okay, explanation comes later. I just need to know if you're agreeing that you committed these violations.
I did commit those violations.
All right, and you're waiving a hearing on them, correct?
Yes.
All right, the court finds the defendant has knowingly waived her right to a hearing and stipulates and agrees that she's committed the violations that have been discussed on the record earlier. These are substantial material violations of the terms and conditions of Ms. Needler's probation. Ms. Needler, I'll get back to you and give you an opportunity to make whatever statement you think is pertinent. But I'm going to ask for recommendations regarding an appropriate disposition, starting with Amber Norris on behalf of the state.
Thank you, Your Honor. Your Honor, the defendant was placed on probation in this case back in July of 2025. As the court previously noted, she has had a previous dip sanction, and that was for a warrant to show cause that the court heard on December 5th of 2025. Your Honor, this is defendant's second warrant to show cause. She just doesn't seem to be a very good probationer. There's not reporting, there's having fairly consistent or regular contact with law enforcement. She's not really doing anything that she's supposed to do, but between the evaluations and making payments. She just doesn't seem to be a good fit for probation with community corrections. I mean, this is the second warrant to show cause for similar offenses, and we haven't even hit the year mark of probation. It just doesn't feel like that she is a good risk for probation, and that she's going to be utilizing the programs or the assistance that community corrections could offer at this point. And she currently has another felony case pending in this jurisdiction, although it's for violations in December of 24 and September and October of 25, but she has another felony case pending. It looks like she actually had bonded out on that case at one point. So I'm not sure if she's being held solely on this case or both this case and the pending case. But she is entitled to some jail time credit, probably. Looks like she got arrested at some point, I think maybe on this warrant on February 6th of this year. Yeah, that's what the return on the warrant to show cause says. So she is entitled to some jail time credit. And she has previously received somewhere around 75, 77 days of jail time credit in previous journal entries. And her underlying sentence is 8 months in the Department of Corrections. But it does appear that the court should revoke and remand her to serve the balance remaining, and that the court will need to address additional attorney's fees and the bids application fee for Ms. Cooper.
Very well, Ms. Norris. Ms. Stanfield, do you take a different position?
No, Your Honor. I've only seen her 3 times in the past 8 months. So she can't even do the simplest of reporting in person. So I just don't think she's a good candidate for probation.
Thank you, Ms. Stanfield. All right, Ms. Cooper, you've heard the recommendations of others. What is your recommendation regarding an appropriate disposition for your client?
Like I said, guys, I have run this girl's cases before. We have seen her previously, one at a time. It was all piecemeal, but we knew who she was. When I went through this warrant to show cause docket, I had no idea who she was until I searched her name. That's how much she changed. I couldn't, if I wasn't seeing these hearings back to back to back, I wouldn't have known that was her. And this is not 10 years difference. I put the dates up. I mean, we're talking less than a year, a handful of months. This girl, the only way that she is going to survive is if she's incarcerated. And that's sad.
Thank you, Your Honor. I'm asking you to consider giving her one last chance at probation. She does have a significant amount of jail credit on this case already, like Ms. Norris stated. I think we're close to 4 months total on this 8-month sentence. So honestly, it would probably be easier for her to simply be remanded to the Department of Corrections and finish out this time. But she wants a chance to demonstrate that she can do the probation. Your Honor, she and I talked about choices that she's made, and she has often made the wrong choice when she's afraid of potential consequences. She's definitely learned them now. She's been in jail since February 6th. So we're at a new, I think we're close to 42, 43 days, something like that at this point. She understands she'd potentially be facing the rest of the 8-month sentence in prison if she is to violate again. And just from the history of a lot of her violations, they do show that she's avoiding the situation she's in by not reporting. She promises to the court and to probation that she'll follow through this time. I know this court let her know she'd have an opportunity to talk, but she was severely injured last year or earlier this year. Even on one of her previous court appearances she made from the hospital. So there were some issues with her health and potential ability to be transported for meetings with probation. But she didn't do the follow through that would have been necessary, and she understands that, and she acknowledges her responsibility there. And like I said before, she just wants one more chance, and I think she'll be able to prove that she can do this. Thank you.
Very well, thank you, Ms. Cooper. All right, at this time, the court will address Melinda Needler personally, and I'll ask her to make any statement that she has that might be in mitigation of punishment here. Ms. Needler, you're wanting to talk?
Yeah, so I just wanted to say that 3 of the 4 probation meetings that I missed in person, well, I guess let me start here. The day that I got in an accident, which was a court date that
Now, just guys, you're gonna have to help me on this because I have heard her reasoning, and I really need someone to explain to me what the hell she's on about with it. I don't know how it's possible. I need you guys to tell me how it's possible.
I get from the hospital was supposed to be one of my reporting days, right? That's where it started. I was supposed to, no, it started the day I was released from the jail after the last sanction I did. I wasn't able to come that day. I came the next day. Well, I ended up being late for work. My boss was going to leave me, and so that's the only reason I didn't make it in to see her. The next 3 times that I missed my probation, I was in the hospital, and I had the paperwork to be able to show her that. I just hadn't made it to her. I ended up, it doesn't matter. It just, I had some circumstances happen that made it not possible for me. I'm on disability. That's why I didn't have proof of employment. But yeah, I guess that's really all I have to say.
Okay. I would presuppose you would take your letters that verify you're on disability and show that to your officer. Did you do that?
No, I didn't know that she needed the letters.
Okay. What was the nature of the injury that you suffered that put you in the hospital that you're saying interfered with your ability to comply with various requirements?
So, I was walking, I was on my way to court, and I had fallen. My jeans cut my leg all the way to the bone. I had to get 19 stitches, and then the leg had got really bad infected. I went septic and was in the hospital for that. I was on 4 different IV antibiotics, several different times, in the hospital at several different hospitals, and I have all the records to prove all of that.
How, guys, please? She was walking, and her jeans cut her all the way to her bone, and then she went septic. See, this is why I only wear knit cotton. I'll never wear jeans again. What? I know. Yeah. One we've never heard before. That is the Ricky bill. I'll show it after all the hearings go. Yeah. Maybe. She can't even walk to court without an excuse, just flying from the sky and hitting her in the face like a toilet seat. Probably. Yeah, that'd be the real question. What was in her jeans that cut her to the bone? I don't, guys, they weren't her pants. Yeah, I don't believe a single thing she says. But to the bone, though, I mean, right? I have a feeling this is the only time we're ever going to see this one. Yeah. If it wasn't, yeah, she has bony knees.
Okay.
And I can also, okay.
Okay, go ahead. No.
In all my records I have, it shows too that whenever I went into the hospital, I wasn't dirty for drugs. It'll show, I can get all the records for that.
Okay. Thank you for your statements, Ms. Needler. The court will note that the defendant was sentenced in this case on May 2nd of 2025. Excuse me, it was that was her plea date. Her sentencing date was actually July 7 of 2025. She was sentenced on level 9 felony theft for 8 months, Department of Corrections, 12 months post-release. And as noted earlier, there was a previous hearing on violation of probation back in December of 2025. That time, the court imposed a 3-day dip sanction. Ms. Needler, I do share the concern that has been expressed by others regarding what you are really a candidate for continued probation. You don't seem to be able to meet requirements very well.
I also wanted to say that I did walk 5 years of probation down on a case out of Dickinson County, and I completed it successfully.
That makes me wonder, why are you doing so poorly in Butler County?
Well, so I just recently, last year, whenever I was released from here, I was released to all of a sudden no home, no transportation. I didn't have my license, and so I have to get all of those things reestablished. Since December, whenever I had my sanction, remember I told you I had a job? Well, whenever I had that accident, I ended up losing my job, and so I didn't have nowhere to stay at that point because I was living out of a hotel.
You see, Your Honor, it is Butler County Court's fault that she cannot be successful on probation, because if you had not locked her up, then she would have had her job and her house, and she'd be a successful graphic designer right now. If it hadn't have been for your incarceration, she had to start over because of you.
Based on the allegations of the warrant to show cause, it appears to the court, Ms. Needler, that while you're on probation, you get in further trouble. You don't report to your officer as directed on reporting probation, mind you. You're unable to show that you're earning your own way in the world by getting suitable, legitimate employment. You didn't pursue your substance abuse evaluation in the manner that you were expected to, or your mental health evaluation in the manner that you were expected to.
I did get the mental health evaluation.
After the warrant to show cause issue. Is that what you're telling me?
No, I got it done beforehand. I did that in December.
Well, according to your officer, you didn't. Ms. Stanfield, do you have a mental health evaluation as part of your record now?
No, I do not.
Okay. So who supposedly did the mental health evaluation?
South Central.
Okay. Did you receive a copy of the evaluation?
I can get a copy of it.
Did you ask for it to be forwarded to your community corrections officer, who is ultimately the one that needed it?
I don't know that no.
Ms. Needler, it just appears to the court that you're just not capable at this point of successfully completing a probation in this case. And this court also notes a couple of other things. Number one, it appears to the court that you have 120 days of accrued jail time credit. 45 plus 3 on a dip, which this court imposed earlier. That would be 78 plus 42 days more on this particular hold connected with the warrant. That all adds up to 120 days, which is approximately half of the DOC sentence that you received from this court earlier. The second thing that I'll note is that because it's an 8-month sentence, you've served half, if you were to go to DOC, it would not be a long stay, but perhaps in the view of this court, an importantly significant stay for you. I think you need to come to grips with the fact that if you don't satisfy community-based sanctions, the alternative is that you do your time. And that's what the court will order, that you serve the remaining balance of the 8-month prison sentence, which the court originally imposed. The court reannounces 12 months post-release supervision. No additional bids amounts will be assessed. Anything previously owed will be sent to collections if it hasn't been already, because it's still owed. I do see that there's 120 days of jail time credit. If the county attorney's office determines that's incorrect, I'm sure you can discuss that with Ms. Cooper, maybe agree on the proper amount, but that would appear to be the addition in the case is 120 days. I'll note, Ms. Needler, that you are entitled to 20% of good time credit with the Department of Corrections. I hope you earn every day of that credit to shorten the stay that you're going to have in DOC. And I just hope you can meet their requirements better than you were able to meet them at this level. So the court will order that Ms. Needler remain in the custody of the Butler County Sheriff's Department until her custody can be transferred to the Department of Corrections to serve the remaining balance of the 8-month prison sentence originally imposed and re-announced here today. All right, Ms. Norris, with that ruling made, is there anything further from your perspective that the court still needs to address?
No, Your Honor, thank you.
Ms. Cooper, I appreciate your arguments on behalf of your client, but I will ask you at this juncture, is there anything further which the court needs to address regarding the Needler case?
Just one thing, Your Honor, please. I know we had asked for reinstatement. Alternatively, would the court reconsider the length of sentence and potentially impose a modified lower number of months, for example,
I've
7
considered
months?
that earlier, but
Thank you.
noting that she's already served half of the original sentence and is entitled to good time credit against certainly with any DOC time that she serves. I believe that the 4 months remaining is the appropriate order for this court to make. So no, the court will not reduce the original sentence. So that
Thank you.
request is denied. But I appreciate you asking, counsel.
Sure. Thank you.
All right. Ms. Needler, you understand the court's ruling here today?
Yeah.
Okay. Again, do what you can in DOC to take advantage of whatever program might be helpful to you so that when you're released back into the community, you can be truly successful. And I think you've got some other cases you still need to clean up, don't you?
Yeah.
Okay. You're going to have to deal with those eventually too, so that you have a chance of being successful at some point in the future. Good luck in that regard, Ms. Needler.
Yeah.
I'll remand her custody to the representatives of the Butler County Sheriff's Department, again, until her custody can be transferred to the Secretary of Corrections facility to serve the remaining balance of that 8-month sentence. There's nothing further. The Melinda Needler matter will be in recess.
Okay, so Wolf Lord Lover wanted to know what was in the top right corner. That is a graphic design that I hired someone to make. And they only did a half-assed job, so then I ended up having to finish it with my graphic design skills. Give me just 2 seconds, guys. I'm pulling it up here. I know it's hard to see in the tiny little corner box, but this was inspired by Mortimer Duke. Because one night he said, "In Ricky we trust." That was all he had to say. And I took it and ran with it. In fact, most of the graphic designs, the images, the phrases, everything, like most of it comes from my chat because my chat is the best. You guys are the funniest, the most intelligent, sweetest, kindest people I've ever met in my life. And I'm honored to have you guys here. So anyways, a couple little notes about the $13 Ricky bill that we see here. It is in the District 01. So like all of his cases, he's actually in the 3rd district. I got that part wrong. But that's what the serial number beginning with D01 is that's his district in Kansas. Not at the present. He's now he's in 03. My bad. But the Great Seal of the state of Kansas is on the left-hand side. If you look, it is, where did it go? Where did it go? Oh, there it is. Next to the signature, it's series 2004. That's when he began his judgeship. Yeah, he's 13th Judicial District, but how do I explain it? So like Judge or Magistrate Webster, all of her dockets begin with MO2 because she's in, like, they have like a grid system where like M is Greenwood, D is Butler. Like, I'm not meaning the judicial district. I'm meaning yeah, she is. But anyways, yeah, 13th Judicial District. That's why it's a $13 bill. But the serial number starts with D01 because here, maybe I can do it this way. Hold up. I'm gonna fix this. I'm gonna make myself sound smart again. Not really, I promise. But I'm going to share my screen. The entire thing. Oh boy. Let me first make sure I have nothing I don't want you to see. Okay. Yeah, entire screen, share. Oh, I love when it does that. Meta. All right. Now, if I go here, court, search court, if I go D01, oh, screw you. Let me go into Drive G. That's got older ones. D01. Oh. There we go. So, see how it says Butler PHC docket, Butler uncontested divorce docket. Like, there was a time where every single docket from Butler started with D01. Now M02 is all Greenwood. So, and are you guys seeing this? I just want to make sure because I'm not sure that it's Jerry. She is the magistrate. Oh, okay. No, it's too small to see. Whoa. Come back. Okay. There, that made it bigger for Eileen. But anyways, yeah. So that's the whole story behind the serial number. Now you guys kind of sort of understand what I was trying to explain, I hope. It goes back to when I first started YouTubing. I mean, that's how I would find everything. If I wanted Ricky, why is my camera fuzzy? If I wanted to find a Ricky docket in my thing, I couldn't just search Ricky. I had to search D03 or D01 would be, I think, D01, I think, was Chad Crum. I believe, possibly. Jan Satterfield, maybe Jan. Anyways, that was the only part of the bill that I regret messing up. The rest of it is like spot on accurate. Who are you? Hey, you quit swatting snitch. Billy? Billy, that was so mean. Why do I smell poop? Which one of you? Okay, I guess I'm going to stop it, Mom. I am not drugged up enough for this. No. I'm gonna put the cases back on. Did you fart? Is that why I smell poo? Oh! Oh my. Okay. I'm gonna take the dog out, guys.
All right, we are adjourned, and the only one left should be Samuel Logan. It looks like he also has a lengthy revocation request. And his judge was Judge Ricky 2.
Judge, do you mean Samuel Brown?
What did I say, Bowen? Yeah, Brown.
Something, yeah.
Yeah, I read it backwards or something. Yeah.
Okay.
And that bond is set at 25,000. Samuel Logan Brown.
Yes, ma'am.
Judge Ricky issued a warrant for your arrest. He was your sentencing judge in Butler County District Court case number 2023 CR 300069. It's alleged that on June 2nd of 25, you were convicted in Sedgwick County of no proof of insurance. Then you failed to report on January 5th of 26. That you failed to maintain suitable employment and make monthly payments, and that you didn't attend alcohol and drug appointment that was scheduled for an evaluation. So basically everything that you haven't done up to this time was listed. Judge Ricky reviewed that. He set your bond at 25,000 cash or surety, probably because this isn't your first revocation hearing. You had one back in April of 24 where you got a 3-day or sanction. So it's 25 cash or surety. I want to make sure you have a lawyer. Your attorney has been.
Hey.
Okay, that's who I'll reappoint for you. Thank you. And your court date with Judge Ricky, as I indicate, is February 27th at 2:30.
Judge, can you tell me what that bond was again, please?
Judge Ricky set it for 25,000 cash
Okay.
security. Which, yep, I double checked it.
Thank you.
Okay, thank you.
Mr. Pate? Mr. Pate, are you now in a position to go forward with your case?
Yes, and that's Mr. Brown there at the jail.
Okay, all right. And then I'm sure I'll have Mr. Sweeney back here in just a moment.
Yes, Your Honor. I apologize for that. I was just checking my file on something.
Okay, it's quite all right. This is State of Kansas versus Samuel Logan Brown. It's case number 2023 CR 300069. Chris Pate appears as defense counsel. Samuel Brown appears from the Butler County Detention Facility Zoom location. Brett Sweeney appears for the State of Kansas. This matter comes before the court at this time for further hearing in regards to a warrant to show cause alleging probation violation. Those violations include apparently conviction of new traffic charges or insurance charges, failing to report to his Sedgwick County ISO, failing to obtain or maintain employment, failure to make monthly payments, failure to attend an alcohol drug appointment and update evaluation recommendations, as alleged by Ms. Ashenfelter from Community Corrections, who is on this meeting with us. What are your client's intentions here, Mr. Pate?
Your Honor, with some explanations that I'll address at the appropriate time, he's prepared to admit to all of them except for the final allegation of the drug and alcohol appointment.
Okay. Is the state satisfied with that statement?
Yes, Your Honor.
All right. All right, Mr. Brown,
Yes, sir.
it's been stated to the court that you now intend to waive any formal due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving the allegations by a preponderance of the evidence. You do have the right to contest the state's allegations with the assistance of your lawyer. You can present your own evidence at such a hearing and confront the state's witnesses unless good cause was shown. Among other lesser remedies, Mr. Brown, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things, Mr. Brown?
Yes, sir, I do, Judge.
All right. Do you now waive a hearing in the case and stipulate and agree that you committed the violations that the court read off earlier, with the exception of number 6, your failure to attend an alcohol and drug appointment to update evaluation recommendations? Is that indeed your intention here, Mr. Brown?
Yes, sir, that is it.
Very well. The court finds that Mr. Brown is waiving his hearing in the case, that he stipulates and agrees that he committed violations 1 through 5 as alleged in the warrant to show cause, but not 6. The court finds that 1 through 5 constitute substantial and material violations of the terms and conditions of Samuel Logan Brown's probation. We'll now turn to the dispositional phase of today's case, beginning with a recommendation from Brett Sweeney.
Thank you, Your Honor. Your Honor, the state is recommending that the court revoke Mr. Brown's probation and order that he serve the balance of his underlying sentence. Our notes indicate that he's had 4 previous dip sanctions. He's got an 8-month sentence, DOC sentence, and he, according to our records, at least has 158 days of jail time credit. So given all of those numbers, I think it makes sense to the state to recommend outright revocation.
Mr. Pate, what are your recommendations to the court?
Your Honor, we are asking the court to reinstate probation in this matter. There doesn't need to be an extension, I believe. I think there was just an extension signed until the end of December 2026. In all frankness to the court, I don't think we'd be here were it not for the January 5th fail to report. Mr. Brown did have a previous probation violation, and that was in April of last year. He signed voluntary jail sanctions on July 9th and December 29th of last year. All of these allegations, except for the fail to report, occurred before at least one of those jail sanctions. He admitted to those things because they're true, but frankly, I think it's a violation of fundamental fairness to just stockpile violations until we're ready for a really big probation violation hearing and then bring them in. Those things certainly could have been addressed at the time he agreed to either one of those jail sanctions. So my point is, as of December 29th, the intent was he was going to be reinstated and the court wasn't even going to be a part of this process, full well knowing all these allegations. Unfortunately, what happened is he missed the PV appointment on January 5th after he was released from his jail sanction. Mr. Brown doesn't want to make excuses for that. He's had some transportation difficulties and didn't have a ride to that probation appointment. He did complete the drug and alcohol assessment. That was on December 29th. After Mr. Brown got arrested, he got with Substance Abuse Center of Kansas. Jennifer Romano from over there contacted me. She went out and met with Mr. Brown, and he was hoping to get started on treatment while he was awaiting this hearing. She discovered he had done this previous evaluation with Mirror. According to Ms. Romano, she spoke with one of the probation officers, and they mutually agreed that he would just start at Mirror upon release. The reality is, and I came up with 170 days, but in any event, whether it's my number or Mr. Sweeney's number, Mr. Brown has done almost all of his sentence. He's got an 8-month underlying, which is 240 days. If he got 20% good time, that would knock it down to 192.
How
So
is he entitled to good time?
I think that's something that it'd be a DOC decision. So I think that it's not really something the court could address, but just stating the fact is that that's what it would be if he got it. So if the court outright revokes him, he's going to get a very short prison sentence, so short he probably won't even go to prison. I mean, arguably, that's the easier outcome for Mr. Brown, is just do a little bit more time and get on down the road, rather than being reinstated and being on probation under the jurisdiction of the court for another 10 months. Mr. Brown is asking that the court reinstate. He wants to accept responsibility, and he wants to get this treatment done and complete it. And frankly, I think that's going to be a lot harder work than just sitting down in a jail cell for a few more days and being done with the case. So based on those reasons, we would ask the court consider a reinstatement.
Has he been in custody solely as a result of this case since January 16 when he made a first appearance?
That's my understanding, yes, Your Honor.
Would you agree with that, Mr. Sweeney?
I do, Your Honor. I mean, I think for purposes of jail time credit, we're giving him credit for that time, which we calculated 42 days. The number that the state was operating under is a number that was provided to us by the Butler County Jail. So that's the days, at least, that they calculated that they had him in, attributable towards this case.
Very well. Ms. Ashenfelter, do you have any additional remarks or recommendations for the court?
No, Your Honor.
Mr. Brown, do you have any statements that you wish to make in mitigation of punishment, or anything further that you would like to present to the court?
Yes, sir, I do. Like Mr. Pate said, I do take full, I agree to all the statements that were made. Due to technicalities, you've seen something in me last time and you reinstated me, and I appreciate that. And that's the reason that I asked to be reinstated today, is because I gave you my word. I gave Brett Sweeney and Miss Ashfelter my word that the next time we meet, that I would successfully have completed treatment.
Oh. How did that work out? Him putting all of that trust in you. You didn't keep your word, sir.
And due to some technicalities, I was this close to being off probation. And Mrs. Smith over in Sedgwick County worked with me. Miss Ashenfelter worked with me. So regardless of the sentence that you sentenced me here today, it's been a blessing for me, honestly, to come to this jail, because I have found my sobriety. I have found that I can't even bend the law just a little bit to make things work for me. It's been 3 years coming. This is an old case, you know, I mean, or 2 years or whatever it may be. But in that amount of time, it's been a blessing, because sitting here in Butler County Jail, I found my faith. I found my sobriety. When I got out this last time, I told you I hit ground running as fast as I could, and I came out running, and I was running so fast I thought I could bend the law and drive without a license and insurance, and I got caught up in that and made it even harder for me. And I kept trucking, and that was back in June, you know, and I kept trucking, and I've already got it in state right now with South Central Mental Health, that I'll have a ride to my appointments. I've got it helped me figure out there's other ways for me to complete my treatment. So if God willing, you guys grant me my probation back and reinstate me, without a doubt, it'll be a success. And you've seen something in me once, and I just asked for you today that maybe you see that again. And I'm sorry for the workload I created for you guys. That's all I have, Judge.
Mr. Brown, why does it take structured probation for you to do these things, if you recognize that you need to do them?
The addiction was one of them that was big deal. The addiction and the mental health, and through me, you know, you sentencing me to mental health, it made me more aware of my mental health. And as I detoxed and I cleaned out the drug and alcohol, my brain started kind of rebuilding itself. And through all the treatment and stuff, like I said, it was all technicalities. You know, I was doing everything I could do to make it to my meetings, you know, driving without a license and insurance. And that's no way, and that's no excuse to make it to my meetings. But I had the support system. I was lacking support system is what it was. And then through my mental health, luckily my case manager, Moses, showed me there was another door. And just over time, it's just me lack of support and knowledge, I would say. And slowly I'm gaining that knowledge. And I know I'm 37 years old. I'm too old to be doing this anymore. And like I say, like it'd be easy for me to go, everybody keeps telling me just go set your time out, be done with your time. And I gave you my word, Mr. Sweeney and Miss Ashfelter last time. And that's the only reason I stand on being reinstated, because I feel like it would be harder 90 days to get out there and keep going and keep my sobriety and keep my focus. And I ultimately I just want to succeed, and I want to show you that, show all of you guys that I'm a man of my word and I can do the work.
Mr. Brown, are you currently under supervision by any other courts?
So the reason I am in Oklahoma, I'm on a year suspended for the domestic that I had that rolled me into the non-person felony. That it's a 5-year running case, because I get out here and like I got court, I think in March, that I'll have to, call from here. I've had court in February. I had to call and get rescheduled. And it's like, I'd be trying to go down to Oklahoma and get that taken care of. That's the only court that I have any issue with, is Oklahoma. And I went down there and they actually threw me in, and the judge OR'd me out so I could get back here, because I told him I had probation up here to take care of. So the judge down there granted me my OR. I came here. I wasn't aware that I was going to be revoked. Came here, got arrested. Then I had to call down there and get it scheduled to get it the case moved. So I'm trying to get it all wrapped up, Judge. I've been fighting it and going back and forth. It seems like with the traffic is I miss court here, miss court there, I'm in jail here, and it's been a huge circle. And it's like I'm so close to having it all wrapped up that it'd be devastating for me to go to prison and then have to get out and go to Oklahoma. Tell me keep trying, because I'm this close to having it all taken care of and back on my feet and back in line. I had a lot of years of stupidity and I did a lot of damage to myself that I wasn't aware of while I was under the intoxication of the drugs and the depression. Now I'm clean and sober. I see how much trouble I've created for myself and how hard, and I've been digging and digging and digging, and I'm close, Judge. I'm really close.
Okay. When is your court date in Oklahoma?
I'm not sure of the March one yet. It was in February. I've got to get a hold of them from in here. I'll have to call down there and get a hold. But as of now, they're just sitting to wait to hear from me what happens here, because I told them I didn't know if I was going to go DOC or not. So I was actually in contact with Brian Mitchell, the assistant DA, and we were discussing signing a deal on a year deferred so I could pay my fines. And that's another reason I would like to keep this going, because I would like to pay my fines too to the state that I owe for. It's only fair.
Very well, Mr. Brown. Mr. Brown, you keep on saying that you're very, very close to being done with everything.
Yes, sir.
Perhaps maybe just, you're almost there. It's more like off the screen.
No, sir. I'm literally that close. It's all down to fines and fees. And if I go to prison, then it's off the screen. Otherwise, it's just 90 days to complete my treatment. Hopefully early dismissal on me paying my fines and fees to the state of Kansas, and then the fines and fees to Oklahoma. So,
Mr. Brown, it strikes me as I listen to your ongoing statement how many things you said are consistent with a recovering addict.
Yes, sir.
Now, whether that you're really saying those from the heart or not, or you're just playing a game, I don't know. Only you know that. But you do say some things that a recovering addict should say. Taking responsibility for your own addiction, for one thing. Trying to take care of business without being impaired in some way. It's funny how life can be simpler if you're just not messed up all the time.
Yes, sir.
Which I think you know very, very well.
Yeah. Yes, sir.
The court's inclined at this juncture to accept Mr. Sweeney's statement regarding jail time days accrued at 158. I think that was the number you used, Mr. Sweeney. Is that correct?
Yes, Your Honor, that's correct.
All right. This court is going to revoke the probation of Mr. Brown at this time and order him to serve 18 more days in the Butler County Jail That will give his accrued time to, according to the court's math here, 176 days. And then I'm going to that is a total of 60 days sanction period relating back to the time he made his first appearance in the case. So essentially it's 42 plus 18 equals 60. And then the court's going to flatten the time, reduce the sentence, and kick Mr. Brown loose. Anything that he still owes on his case is going to be immediately due, payable, and collectible.
Oh, so that rehab that you were saying that you wanted to go to, you are going to be responsible for the cost of it, not the taxpayer. Sounds fair. I do hope he gets the treatment that he needs. I really, truly do. But I think Judge Ricky is making the right decision here.
That juncture. So if you're going to have collection fees by a civil collection agency if you don't get the case paid off at the end of that 18-day period. But it's gone on long enough, and if you still owe something, that can be sent to collections 18 days from now. Mr. Brown, I don't know that you've necessarily earned, in the purest sense, a reduced sentence, but it does make practical sense. Hopefully you can schedule your Oklahoma court date just after that so you can get to Oklahoma and get that taken care of. If you really mean what you say today, then that's one of the steps that you need to take so you're not having court systems on top of you all the time. Okay? And I know that there's been a lot of effort made toward your rehabilitation and your probation by various officers in the case. I commend them for their effort. They've been partially successful with you. But I think now and for the rest of your life, Samuel, you're going to have to make good decisions on your own, not because of your probation officer, but because of you.
Yes, sir.
If you mean what you said today, I think you've got a good chance of being successful, Samuel.
Thank you, Judge. If it wasn't for you guys,
you owe us 18 more days.
yes, sir. If it wasn't for you guys, I wouldn't have been able to do it. It was the structure that it was the structure and the rehabilitation of here that did it.
Well,
So
I'll give Ms. Ashenfelter all the credit for that.
Thank you, Ms. Ashenfelter.
But I think 18 more days in jail, complete a 60-day sanction period, and then we're going to terminate your case with that being the total number of days ordered by the court, which again, that figure was 158 plus 18, 174. Was that the number?
176.
176. 176. That's correct. Very well. Since the court's not going to be assessing any more fees for this round of proceedings, Mr. Sweeney, are you aware of anything else that needs to be addressed currently?
So I just want to make sure that I have semantics right, but essentially 18 more days to complete a 60-day sanction, and then the sentence is modified to 176 days.
Correct.
Okay. I think I'm good for the journal entry. Thank you, Your Honor.
Mr. Payne, anything further at this time?
No, Your Honor. Thank you.
Good luck, Samuel. Be one of this court's success stories.
Thank you. I appreciate it, Judge. Thank you, Mr. Pate.
All right. Thank you.
Remain in custody back to the jail until he can serve 18 more days before his release on this case.
Yes, sir.
What time are we?
Samuel Brown matter is in recess at this time.
I was actually, I was looking for a Judge Oakley case that I saw just the other day. Give me just 2 seconds here, guys. Because I know I watched it. It was a truancy case. Okay, it's gotta be in this docket here. All right, give me a second. I'll let you guys chime in here as I'm doing this. I cannot see the court at the moment, by the way, just so you know. but give me just a moment. I'm looking for a specific case. I know we all love Judge Oakley. I love how down to earth he is. He's just spot on with life lessons. to put it simply. He's a man of life lessons.
Deal with your grief.
See here. Yep.
This is
Here we go. I knew I would find it here.
Counsel, your appearance.
All right. We're going to watch this one, all right?
Nothing else, we're probably going to reduce the total on your payment plan. All right? It'll be worth your time, trust me. You're welcome.
If she comes up to, just tell her to wait a minute, okay? Thanks.
So
Response, civil and right.
I didn't think we did.
Trying to find something to put it under.
It don't matter.
Oh.
Right? What the hell?
Right. What, how much?
You're 150. What's the name on it, Joe? Kuster?
Just gonna be double parking.
Whatever you want to do, C or K. K. Civil infraction. It's a civil infraction, isn't it?
Yes.
I'm on a new computer. Oh, I got it. Okay, I got it already. It's on and on. For the wife.
Oh, that you have to get these from the court officers at the desk.
You got it. People versus Custer or Kuster? How do you say it? Custer, come on up. Counsel, your appearance.
Attorney Thomas Ford, P77-177, appearing on behalf of the defendant who stands for right. You say
Good morning. And counsel, I understand Ms. Custer is going to plead guilty?
Yeah.
Ma'am, do you understand your rights and options? You discuss those with counsel? Yep. And do you understand the possible penalty for the charge? Are you as nervous as you look? Take 3 big breaths. Seriously, just breathe. I got all the time in the world today. Just breathe. We'll get you through here. It's not my first rodeo. Just take the anxiety down about 50%. You're not going to jail. This is going to be, you're going to look back on this and say, I didn't even get a t-shirt. You all right? Okay. You understand the possible penalty? Yes? She's recording, so doesn't record very well. So understanding all of this, you're pleading guilty, and are you doing so freely and voluntarily? Okay. So how many kids are we talking about? 1, 2? 1. Son or daughter? What's her name?
June.
June like the month? And how old is she? All right. So she's almost going to be human again. Another year or 2, she'll be human, right? All right. How many days did she miss?
Roughly 115 hours is our understanding.
Okay. All right. Are you satisfied that that's enough of a factual basis for me to accept the plea?
Yeah.
So am I. All right. So what's going on? I'm sorry. I'm sorry. Yeah.
Yeah. But she does have the option to take the bus.
Okay. Okay. So it's a twofold problem. You kind of checked out for a while because you lost dad. And she's not taking responsibility for her education. Okay. All right. So a couple thoughts in my head right now. First thing is, are you in grief counseling? Go. Grief counseling. First thing I always tell people is contact the funeral parlor, wherever your dad went through the funeral home. A lot of funeral homes have grief counseling on site. All right. But if you just Google grief counseling near me, I will be shocked if you don't have a lot of options. And my limited experience with them is through the funeral homes. It's usually free. Okay. I have never, and I've made people go to grief counseling. I've had people on probation. I made it a condition of probation. I'd never had anybody go through grief counseling that told me it was a waste of time. Okay. I'll share a little story. Counsel, you're near prison. I'm going to share a story for you. Her predecessor lost her father. A year later, I was still dealing with in the middle of a docket, she'd get up and run out. So finally I pulled her aside and I said, how much do you like this job? I love this job. I said, I'm going to fire you. You have got to figure out a way to deal with your grief because this is unhealthy. Okay. So she went to grief counseling. From that point forward, when I was having this conversation with somebody standing where you're at, she would look at me and say, Judge, can I take over? And I'd say, go ahead. And for her, the main thing grief counseling did for her, and I know this because I heard her tell people this all the time. For her, and I'm not saying this would be what you get out of it, but what Paula got out of it was they told her, schedule time every day to grieve. First thing in the morning, last thing before you go to bed, while you're making your lunch, schedule some time to just think about your loss, deal with it, cry if that's where you're at, schedule time to grieve. Because that way she wasn't just trying to bull through and it would overwhelm her because something was said or something she heard would remind her of her dad and her loss, and she'd like be on an emotional wreck for 15 minutes. Okay? Pretty simple thing. Right? But she didn't come up with it on her own. It was grief counseling. So is that a pretty good sales pitch? Okay. And I'm going to suggest if June was close to your dad, she might need it too, because that might be part of her motivational problem. All right. Now, the second thing I want to tell you is this. If it's just attitude, bring her in here. Let me talk to her. Let me impress upon her how at 14 years of age, she has more responsibility for her education than you do. I love to tell people how to live, especially kids. Okay? So if that's something that is attractive to you, her name is Heather. You can get on our email through our website and you can start an email conversation. Just say, I need to speak to Heather to schedule a meeting with Judge Oakley and my 14-year-old almost human being daughter. Deal? Okay. Last thing, I'm getting to a sentencing, counsel, I promise you. Last thing is, we've got lots of resources available to us, okay? I could get people to answer the phone for me just because of this, that you might not be able to get them to answer the phone, okay? So if you're having trouble getting her properly motivated and you think we might be able to help you find resources, just come back to probation. Just walk up to the probation department and say, I was in front of Judge Oakley on the 23rd of March. We talked about my daughter and her lack of motivation for school. And I'd like to tell you what my problems are and see if you guys have any suggestions. You got all that? I threw a lot of information at you. All right, so let me tell you what your sentencing is. You're on a delayed sentence for the next 12 months. What that means is no crime sprees, don't commit any new crimes, right? And the problems we're having now with June in attendance don't continue. All right. That's it. I'm not charging you any money. So keep your nose clean. Things get better with attendance. And if they're not, then you come back and see us and say, look, I've done everything I can. All right. One last thing. I lied to you. One last thing. Remember, your mom, you have legal responsibilities. You have to feed her, house her, and clothe her. You don't have to feed her what she wants. You don't have to house her and keep her comfortable, and you don't have to clothe her the way she wants. You just need to make her so she's not naked, she's not in the weather, and she's not starving. So that means don't let her be comfortable under your roof if she's not doing what you want her to do. And I understand, I've done this a long time. I understand that that usually means everybody in the house is getting punished to some extent, but if it corrects the bad attitude behaviors, it's worth it. Okay, that's the end of the lecture. Anything else?
No, just quickly, I'll say about my friendship, she's never been before. She did adopt this child at a young age who was born with drugs in her system.
Yeah.
She's doing a very good job. Normally they hit a quick stumble stretch, but I'm confident that they won't be.
Yeah. Yeah, so she came with some issues. Yeah. 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 You feel a little bit better than you did when you walked in? Okay, good luck.
I have so much respect for Judge Oakley. I really do. I love him. I think he is a phenomenal judge. He really, truly cares about people. You don't get to say that enough in this world. All right, guys. I just wanted to wanted to share that little clip of life inspiration message. I hope it helps those who it needs to reach. Thank you guys all for coming and hanging out with me tonight. I'm glad you guys were here. I won't be going anywhere. Probably tomorrow either. Because it's already really slick out there. Yeah. Ava did the Bambi all four legs in different directions thing when she hit the deck. It was very entertaining. If I knew the freezing part of the rain had started, I would have had the camera out ready to record that shit, but I didn't. I knew it was raining. I didn't know that it had already frozen. You guys are the absolute best. I'm so grateful for how kind you all are to each other. It's kind of the number one rule around here. We make fun of the defendants. We can make fun of the judges, prosecutors, defense attorneys. Have at it. They are all fair game. But we take care of each other here. Be safe, be well, sleep sweet, and much love.